Welcome to Top Tips. Each session, we will provide you with 5 simple tips to help you with your IT or with your data. If you manage or work in a business between 1 and 50 employees, then these tips are specifically for you. Each tip is non-technical and jargon-free. You need no technical experience to use the tip. Each one is intended to be simple and effective. My promise to you, 5 bite-sized tips in no more than 15 minutes. We'll give you the tip and tell you why it will help you. It's all positive and not intended to intimidate or to scare you. If you have any questions, please add to the comments at the bottom and I'll get back to you. Today's session is about data protection and simplifying the GDPR. Don't worry, it's not going to get too dry or too legal. Now, before we start, it's important to understand the benefit of these tips. These tips are all about how to ensure that your business is storing and processing its data according to the data protection laws and how you can use this to your advantage. This allows you to be confident in what you're doing and know that you don't have to worry about the fines that regularly hit the headlines. The GDPR, or General Data Protection Regulation to give its full name, is a European Union regulation that covers all EU citizens. When the UK left the EU, it adopted the GDPR into UK law. So if you are a UK company, then you have the same obligations as before. There is much to the regulation and we're only scratching the surface today. Before I go on, I should say that none of this content should be construed as legal advice. If you need specific legal help on any data protection concerns, then get in touch and I can direct you to some trusted associates who can provide you with specific legal advice. Now, when processing personal data, the GDPR is designed to ensure the following. It must be lawful. That really goes without saying. There must be clear explanations on what is being done with the data. Individuals have a right to understand exactly what organizations are doing with their personal data. Only the absolute minimum data must be used. Companies must only take the data they need for their specific purpose, and they must keep it only for as long as they need it for that processing. This is known as a data retention period, and it should be as short as possible. Some people think that there are standard data retention periods, but there isn't really. If there's no need to keep the data, then it needs to be deleted. Oh, and of course, the information must be safe and secure. This runs through everything. I've covered this before in Data Security Top Tips, so for today, let's just take it as read, going all the way through this presentation. Now, this is normally all stated within the privacy policy or the terms and conditions, which yes, most of us just click through, but it's essential that you have all of this laid out within the appropriate documentation so that everybody is clear on exactly what is happening with the data. And as an organization, if you are processing personal data, then you must adhere to these data protection rules. The penalties for failure can be severe. So here are 5 non-technical tips in less than 15 minutes designed to guide you around this topic. Tip number 1. Don't be scared of the GDPR. As a consumer, it's a good thing. It's designed to stop our information being used in ways that we are unaware of or without our permission. I can see you thinking though, hang on, I'm a business owner. GDPR really hampers me and stops me contacting my potential market. It's just red tape that stops me making money. Well, the data protection laws and the principles of GDPR are good for all businesses as they ensure that you are structuring and storing your data in a fashion that enhances your business. By doing this properly, it generates trust with your consumers, with your customers, and that in turn will generate customer loyalty and better brand image for you. Now, equally, GDPR should never be used as an excuse not to do something or not to reveal information. Telling me that I can't have information because of the GDPR is just a red rag to a bull. It just drives me mad. It's just lazy to be using GDPR as an excuse for why you're not doing something to meet your customer service. GDPR is principally about being transparent and clear. And clarity, surely, is always a good thing. Tip number 2. The GDPR only applies to personal data. Personal data is defined as any information that can be used to identify an individual. It only applies to living individuals, and it does not apply to corporations or roles attached to these organizations. So, for example, alan.patterson@aikadvisory.com is considered personal information. MD@aikadvisory.com is not. Personal information covers all sorts of things, including name, address, date of birth, and even facial recognition these days. On top of this, there is special category data that exists that requires even more protection. This includes medical records and other sensitive information. Now, if you want to reduce the burden of red tape, then I recommend that you anonymize as much as possible. If you can't identify individuals through the data, then the GDPR will not apply. But it must be totally anonymous. You shouldn't be able to link it back to any other data to reveal the specific individuals. You can't just have one file with anonymous data and a second file with the personal data within it that you can link easily together. That is not anonymous. That doesn't count. Tip 3. Understand your role and what you are doing with the data. There are 2 important roles when processing personal data. The data controller is the owner of the data. They are responsible for it and all the activities that are undertaken. Any questions or requests about that data need to be directed to them. Data processors undertake activity on that data, but they are working under the direct instruction of the data controller through a data processing agreement. The data processing agreement defines the responsibilities of the data controller, the data processor, and the specific activities that will be undertaken. Think of it as a data contract. If you have any issues with what's happening, this is the first document that will be consulted. So, if you are working with personal data and you're passing this through to another company to process on your behalf, then you are the data controller and you need to ensure that you have a data processing agreement in place. Tip 4. Be ready for data subject access requests, or DSARs. Know what to do if a customer, known here as a data subject, asks to see their data. Everyone has a right to contact an organization and see what information is being held on them. It must be provided within 1 calendar month from the receipt of the request and must be complete and accurate. Some organizations will receive a large volume of these, others may get a few. But if you are processing personal data, you need to be ready for them. They can seem very intimidating if you're not used to them. Equally, anyone has the right to ask for the data to be deleted from your systems or for corrections to be made. You have a legal duty to carry these out. So it's worth having processes in place to support all of this. If you have your data processes documented, then it need not be difficult and it should be very smooth and easy to implement. Tip 5. Consent is not the only option. We talked about lawful processing at the start, and many think that you need to have consent in order to process an individual's data. This is not always the case, but it's certainly a good thing to have. There are 6 different lawful purposes, of which consent is just one. The others are performance of an existing contract, having a legal obligation to process that data, where it's in the public interest to process the data, or where there is protection of vital interests involved, or legitimate interest. I'm not going to go through all of them, but the other that is most popular within organisations is legitimate interest. This tends to be used as the alternative when sending communications to potential customers. Organisations will claim that they are sending out important information that individuals really need to know. Now, it's perfectly reasonable for you to use legitimate interest, but you need to be very clear and you should have tested it legally prior to using it. It's certainly not an open-ended opportunity to do what you want. The ICO suggests that you apply the following 3-part test. So first, identify if it is a legitimate interest, i.e. through looking at the specific purpose. Second, prove the necessity of why you are doing it. And thirdly, balance it against the individual's rights. So again, is it fair and reasonable to an individual that you are processing their data in this fashion? Now, it's not a legitimate interest, for example, to contact specific individuals telling them that you are in the area and that you are offering 50% off new windows and doors. But it may be a legitimate interest for a company to pass details of customer debtors onto a debt recovery agency. You need to document your assessment of each test so that you can back this up in the event of any queries in the future. And finally, going back to consent for a minute, when you are collecting consents, it's important to store them accurately and appropriately. Consent can be withdrawn at any point, and this must be respected. I may well do a future top tips just on the subject of consent in its own right. So those are the 5 tips, but finally, I just wanted to give you some extra information. The Information Commissioner's Office, the ICO, is a very useful resource. Although they are the legal authority and they will come and find you if you're breaking the law, the ICO mainly seeks to support us all and help us meet the regulation. They are particularly interested in reducing the chances of data breaches and the misuse of personal information, either through sharing with inappropriate parties or through contacting individuals in unwanted or inappropriate manners. You can find them at ico.org.uk. There's a lot of helpful resources there, and it's all written in a very simple fashion. Now, that's the end of the top tips. I only scratched the surface, and I haven't dealt with anything to do with cookies or the Privacy and Electronics Communication Regulations, PECA for short. That's a far, far more technical subject, which maybe we'll come to on another day. Okay, that is 5 tips in 15 minutes, designed to be simple and easy to use, and I hope that you found them useful. I'm Alan Patterson. I work for AIK Advisory. We offer data services and advice. We simplify technology, and we operate in a very collaborative fashion. Specific to this, we offer a data security health check, which covers topics like we've been discussing today in far greater detail. We also provide our hierarchy of data needs assessment that ensures that you are using the data in your business in the best possible manner. You can find out more at aikadvisory.com and see some of the nice things that people have said about us there. You can find me at alan.patterson@aikadvisory.com or on LinkedIn. So thank you very much for listening and watching this. I hope to see you soon. That was good.